Welcome to Queen City News Plus Live. We got Order of the Court today, and I'm anchor Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Good to see you, my brother. How you doing?
I'm good. I have zero complaints today. Zero.
Oh, I love it. Well, that's pretty good for a Monday as we were taping this. No complaints, and that's a good thing, especially when we got gorgeous skies outside today.
It's beautiful.
Talk about some legal issues as we do 3 segments today, Khalif. And the first one we're going to talk about, which has always been a big talker as court is in session, Live Nation settled with the DOJ today. You remember this is the one where it got all in a big hullabaloo with the Swiftie fans. Taylor Swift, they couldn't get in to get their concert tickets, and then they were like unbelievably groaning and moaning, caused a lot of problems. And then, you know, they said that there was a DOJ was like, this is a monopoly or antitrust case here, but Live Nation wound up settling this case today. So give me the details of this.
Live Nation and Ticketmaster come to a settlement with the Department of Justice, $280 million payment to states, allow competitors like SeatGeek to sell tickets at Live Nation venues, and they're required to sell some of their amphitheaters. There are 39 plus states involved in this lawsuit. The states can continue to go forward with litigation. You're talking about New York, that's Letitia James, who brought claims against President Trump in the past. California, Massachusetts, Connecticut, right here, North Carolina. Jeff Jackson, our Attorney General, has already said that he is going to continue with the claims against him. And
when South Carolina joined the DOJ,
Alan Wilson, so
they're doing it. They're going with the DOJ.
North Carolina decided to go against it.
Yeah.
And I can tell you why a number, I'd say the overwhelming majority of the attorneys general will decide to go forward with this case. This is a antitrust case. This is brought on behalf of the Sherman Antitrust Act. You are talking about a monopoly, Brian. That's what they're alleging, right? And it's not just a monopoly, but it's a anti-competitive monopoly. And so what they're saying is that this remedy, which you've put in place, is nowhere near enough to stop the anti-competitive monopoly. 20+ billion with a B dollar annually is what Live Nation brings in revenue. This settlement of $280 million is the equivalent of 4 days worth of revenue. Yeah, it may seem like a lot of money, $280 million, but it's not much to a company their size. And what they're saying is they can make up this money that they lost, and it's not deterring this type of behavior. What is the behavior? Artist promotion, venue promotion, ticketing distribution. They control all three. And if they can control all three, now that monopoly can become unfair, it can become non-competitive, and they can squeeze out smaller individuals or smaller companies like a SeatGeek or anyone else. And so this is going to be a problem, and I can see why a number of states are saying we're going
to do it ourselves. Yeah,
we'll just do it ourselves. Federal government, you're deciding that you don't want to go forward with this. Department of Justice, well, thank you for telling me no, but we have the resources, we have the manpower, and we have the case law on our side. That's what they believe.
You know, this has been talked about for quite a while before it came up with this Taylor Swift concert deal. In many cases, as far as the monopoly goes, but this trial had already started here. So this was something that they settled in mid-trial, and that was something that Live Nation thought was in the best. And everyone's saying this is a win-win for everybody here, as far as the consumers, especially, and also the artists.
Well, a couple things. You mentioned it starting. The trial already started. This is week 2. So the first thing that the judge said was, well, this offer to settle was signed Thursday. You guys brought this to me on Friday. The judge questioned it and said, well, why'd you bring it to me on Friday? If this was signed on Thursday, how come I didn't get it on Thursday? That was the first question that the judge had. And remember, all agreements, all deals, even though both parties are saying they want to go forward with this, the judge will still have to be the final say to say if this agreement is something that they'll allow to go forward. But I can tell you that you get to that point in trial and you're saying, how much is it going to cost us to continue to fight this? Do we have a case that's winnable? And is the likely result, if we lose, going to be worse than us paying this money right now? If Live Nation were to go to trial and lose, you could look at them possibly being broken apart. That's the part that you would want to avoid. That structural remedy, that's probably the most powerful when you're talking about antitrust cases. You want to say like AT&T breakup of 1982, Standard Oil breakup of 1911, American Tobacco Company breakup 1911. Those are cases where the federal government decided, hey, you guys have gotten too big. You have now not just created a monopoly, but an unfair monopoly, and we're going to have to break you up. That structural breakup of a company, of Ticketmaster and Live Nation, would be better than what's recommended because now you can allow competition, fair competition, to get within the cracks of the organization.
So, going forward, how fast does this breakup happen? And does it matter because it seems like it can get kind of convoluted between states now, like
Yeah,
what you're saying, North and South Carolina.
yeah.
South Carolina chose to go with the DOJ settlement. North Carolina and Jeff Jackson filed to go on with their trial. How do you think that plays out over the next few months and years?
Well, if you're an
Hopefully
individual,
not years,
if,
right?
if you're a state that decided to join in with the Department of Justice and agree to the settlement, you'll get whatever distribution of this settlement payment that goes to your state allocated, I'm assuming, based on the users that were affected in your state. If you don't and you reject that deal and you go forward on your own, now Jeff Jackson and his team in North Carolina specifically will have to go, have to prove their case, will have to make sure that they're able to show that not only did they create again a monopoly, but they created an unfair monopoly, and they allowed that unfair monopoly to kick out and to stop, the stymie competition. If they allow that to occur, they're going to show like this harm to consumers was high fees, ticket scarcity, lack of innovation. Those are the things that they'll have to be able to prove. And if they can prove that, then the state can say, hey, we're forcing them to divest. We're forcing them to split up. We're forcing them to sell venues. Those are all the things that, or we're looking for a larger payout. And then the state, because it would be a state by state basis, would then be able to bring, have it distributed to their own individual uh, uh, users that were in their state. I ultimately think it leads to settlement. It just leads to settlement on a larger number.
How fast can we see how fast can we see something like a SeatGeek start taking over in some of these
The
operations like
second
what
the
we're
judge
talking about?
approves this deal, when the judge approves this deal, part of the settlement agreement was that SeatGeek would now be able to sell tickets in the venue, in Live Nation venue. So
And other ticket brokers, yeah.
and they said that they would be able to sell some of their amphitheaters. So I mean, best case scenario, the judge approves this agreement this week, and then consumers start to see these type of things take action instantly.
Okay. Well, we're going to leave that one there, and we're going to see where this goes. Obviously, Live Nation, big presence here in Charlotte and also around the Carolinas as well. We're going to come back and we're going to talk about something a little bit more sinister, and that is, is a North Carolina law student has sued the school and administrators over alleged unconstitutional disciplinary process that resulted in him being banned from campus and also being banned from graduating. So we'll have that story coming up. You're watching Queen City News Plus Live and also with Order in the Court with Khalif and Brian. Welcome back to Order in the Court. Got Khalif and Brian here talking about their second segment here on as court is in session. And we were talking about a former University of North Carolina law student, Khalif, who has sued the school and administrators, alleging that they initiated unconstitutional disciplinary action resulting in these protests that were happening in Atlanta with Cop City. And it also banned him from being on campus and also also blocked his graduation attendance at the University of North Carolina, Chapel Hill.
Yeah, so there was a Cop City protest in Atlanta in the forest, and so it was connected to a number of things. First, the argument was about deforestation issues, and then it was just over policing in different communities, and so they were protesting there. In the course of the protest, Marsicano was arrested. Marsicano gets arrested down there, and then because she's in the middle of law school at the time, UNC then kicks her out of school, right? Kicks her out of school, and while the things are pending, now the problem with this is the details. And looking at the complaint, about a 30+ page complaint. While arrested, the school, or still I should say, while still detained, the school sends an email saying that you have been put on leave, and if you want to appeal this leave, you can submit a request for a hearing within 7 days. Well, gets out of jail, waits 3 days, sees the email well after the time frame to request the hearing. And the school says, well, because you requested the hearing late, we're going to put you on leave anyway because you've now exceeded that time frame. So lawsuit alleges a USC 1983 claim that's for a violation of due process rights. That because I didn't have an opportunity to and I wasn't properly notified, given notice of my rights to defend myself in this hearing, you have now unconstitutionally removed me from unilaterally is what they say in the complaint, but unconstitutionally removed me from school, unconstitutionally removed me from going through the graduation process, a number of things that other students similarly situated would have been given that right to do. And because you didn't give me that hearing notice and opportunity to be heard, I believe you violated my rights.
Yeah, and prosecutors also added this quote unprecedented racketeering charge on top of things to the indictment. It was later dismissed, but discuss what that is all about.
Well, that racketeering charge is because they believed that there were a number of individuals that were connected to this incident and other incidents across the country, and funds were being funneled and kicked back to try to support this and these types of efforts. And so I think that prosecutors were attempting to try to get unique and novel with their approach to try to deter individuals from participating in these type of constitutionally protected activities until they get violent. So they were protesting and prosecutors were saying, well, now you've crossed the line of protest and you've become violent and you're funding this violence. We're going to throw a racketeering charge on. But as you mentioned, these charges were dismissed. And that's often the problems where you have an individual that has these instant effects to their job, to their school scenario, because of a charge. Then the charges get dropped and then they have to pick up and figure out, okay, where do I go from here? In this scenario, Marcano's like, well, I still graduated. I got that opportunity to graduate, but my moment was taken from me, and it was taken unilaterally without my substantive due process and without my procedural due process. Moments having had the opportunity to be heard in the hearing.
So, as a criminal defense attorney, you've seen a lot of things come across your way. I've known you for what, 7, 8, 9, 10 years almost, and I've seen a lot of you with a lot of different cases. Have you ever seen anything like this as far as this goes?
I've seen it. I've represented individuals against universities in the past, and so I've firsthand knowledge of procedural due process violations, and substantive procedural and substantive due process violations. Both of them are saying you have violated my rights, and so I've seen them. I think what makes this complicated and convoluted is that this case is stemmed in Georgia. They were dismissed. The underlying charges were dismissed, but the action still took place. And I mean, that portion happens more than you know. I mean, I have probably 10 clients right now that have lost their jobs as a result of being charged, but then were ultimately the charges were dismissed, and now they're just having to pick up their lives. I mean, my last one was a truck driver driving his truck, lost his license during the process, lost his job during the process, end up getting the case dismissed, but still now doesn't have a job because of that. That's the type of thing that is a secondary effect of our judicial system.
Tremendously secondary effect that changes the
It
course of your
does.
life.
It does. I mean, and that person has to deal with that. And so back to this case, it's the same way. I only get one law school graduation, unless you're like me, where I graduated with my law degree and my advanced law degree in corporate law and finance. I did get two law school graduations, but most people don't get that. Most people will go graduate with their JD, their Juris Doctor, and that's it. So I know for sure that those are the things that you can't throw money at it, right? They're asking for compensatory damages. They're asking for punitive damages, but money's not going to fix those memories that you would have gotten if you wouldn't have kicked me out of school and had me take a semester on another campus. Those are the type of things that you're suing to try to, I guess, monetarily get it back. But even if you're successful, you're not.
Do you see a settlement coming in this case?
Probably not. This is one where it's going to be hard to prove that they didn't give him the due process because they sent a message. One thing they say in the complaint is that he was incarcerated in jail at the time, but the notice went out. It went to his email. He just wasn't in a position to read it. Now, if they had failed to send an email and had a hearing without him getting any notice, I think that's an easier one. But now you're going to have to get them to concede and at least say, hey, we sent you this, you didn't respond, and we didn't give you an opportunity to respond because you were incarcerated. We could have probably given you more time. Looking at what the rules say for them to get how much time, how much notice is required, that's something that is going to be in their policy manual. And I would suspect that whatever time frame they gave him was consistent with what's in the manual.
Okay. Well, we are going to leave that one there too, Khalif, right now. And then we're going to talk about another case that's out of Utah involving a protest. And that was the widow of a man shot and killed by a so called peacekeeper during a No Kings protest in downtown Salt Lake last year, has filed a wrongful death lawsuit. We'll have more on that one coming up after the break. You're watching Queen City News Plus and Order in the Court with Khalif and Brian. Welcome back to Order in the Court. Court is in session here with Khalif and Brian. And Khalif, right now we're going to be talking about a case out of Salt Lake City where this was a widow of a man who was shot and killed by a so-called peacekeeper during a No Kings protest in downtown Salt Lake City last year. They filed a wrongful death lawsuit accusing the gunman and the organizers here in the rally.
This is a very, very hard case to look at. So let me start with a couple things. They're having this protest, and the organizers are trying to find, as you mentioned, and as they labeled in the complaint, peacekeepers. What they did is that the organizers asked individuals to come, and protect and to be, guards at this rally, and to bring your firearm and to peacefully ensure that nothing happened. So what's happening is that this individual is there, and he has his AR-15. It's unloaded, and he's walking around during a protest lawfully carrying his firearm. Well, one of the peacekeepers, he sees this individual, and he believes that there is a mass shooting about to happen. So he shoots at that individual 3 times. Shoots at that individual 3 times, and that individual, Mr. Gambiel, was not killed. The individual was killed that was 150 feet down the road with his camera recording the incident. On the 3rd shot, he's who got killed. And so what they're attempting to say is that you guys is just like a normal tort claim: duty, breach, causation, and damages. You have a duty to be able to ensure that people coming to your event as an organizer are safe. You breach that duty because you have these individuals here that you didn't do a background check on. You have a number of individuals that they asked for law enforcement with former military, but they weren't sure. They didn't make any checks to see, well, what type of training have you had to do some type of peacekeeping procedures? What type of training have you had for large scale? Because they said it was 10,000 plus people there that day. What type of large scale training have you had to ensure for crowd control? Those are for recognizing mass shooter type of events. Those are the things that they're saying they failed to do. And because they failed to do them, they're saying that they're negligent because they were foreseeable, reasonably foreseeable that this could occur, and that your failure to check these individuals' backgrounds and history and training led to this occurring.
We have seen a lot over the last few years, a lot of protests that have gotten very out of hand, very violent. People have died. Can you foresee any kind of laws being changed that or need to be changed when you see something like this happen in this case?
Well, the issue is that, I mean, the individual, the person that Mr. Gambio that was carrying his AR-15 lawfully, he wasn't breaking any law. I mean, you're in an open carry state. Carrying a firearm was Utah allows open carry. His activity wasn't illegal. I mean, so then you'd have to, throw out the open carry laws in your state. But then even after that, probably some type of law that requires individuals doing policing or peacekeeping
Peacekeeping.
at these events, be law enforcement officers, trained and have a special requirements before they're allowed to go and do that type of activity. I think that would probably be the best type of change. I mean, but this is the remedy. The remedy for when scenarios like this happen, even it's the worst type of situation you want to have as a spouse. My heart goes out to the family, to the woman who brought the claim on behalf of her husband, to have to bring a wrongful death claim. That's damages, death being the worst type of damages. No one could say that this is how it's supposed to play out. But when something bad happens, oftentimes litigation is the next step. You can have legislation passed to change and create laws, but litigation is typically where you'd go and you'd say, hey, can I hold that company, that organizers vicariously liable? Meaning the action of this person that they hired can I hold you responsible for that? Yeah, you guys didn't go out there and pull the trigger, but you hired this person negligently, and you didn't do the things required to ensure that something bad could happen.
And do you see this case going to trial as far as for the investigation that was there for Charlie, because Adler was charged with manslaughter here.
Yeah, I mean, so obviously with that type of case, the individual that was charged, I think it's going to be a hard case for him to defend against the manslaughter charge. You can have self-defense or defense of others, and the defense of others has to be reasonable. That what your action that you take in that time is reasonable to save your life or the life of another person. And you have to be in imminent fear of bodily harm or believe that this other person is in imminent fear of bodily harm before you act. And it can be commensurate. It could be, the amount of force that you use can be commensurate with the amount of force that you are seeing. So if he saw an individual what he believed with a firearm and was going to open on a crowd, he would be justified in using that force to stop that. If he believed that person was, again, a threat to him or someone else. The only issue is the firearm wasn't loaded. And would he be able to know that from the distance he was at? Probably not. And that's why
Does it go to trial?
I think his case would probably ultimately go to trial. Now, regarding the civil claim against the organization, I think this is one that you go to trial with as well, because they'll argue that, hey, we have no duty as an organizer to ensure the safety. I'd rebut that and say, well, you do, because you hired these folks to come out here and once you hired these people to provide this peacekeeping, now you have inserted yourself in as a party in this claim. And so I think both sides will be cemented in their position. One saying that you had a duty, the other saying I don't owe a duty. So yeah, this one goes to trial for sure.
All right, we're going to leave that one right there, and want to appreciate everyone for joining us on Order in the Court today. Court is out of session with Khalif and Brian, and thanks for watching here on Queen City News Plus. Appreciate it.
Queen City News Plus. Just search Queen City News on your smart TV's app store.